Hello, once again, Employment Law Show. John Scholes, beside me, Lior Samfiru, Tumarkin. That is the name of the law firm you want to reach out to anytime. We'll throw the contact information up on the screen throughout the next 30 minutes. But right off the top, 1-855-821-5900, help@employmentlawyer.ca. And if you simply go to employmentlawyer.ca, the website, that'll jettison you right to the firm website. And while you're there, many things to be learned, as well links to our long-running radio show. We'll get to some calls pulled from the radio show a little later on today. Lior, as you know, plus all about the truth about independent contractors. That is coming up later on. You do not want to miss this. You might be able to stroke and check off some of those boxes as we go through the show. So listen up indeed for that. But we always start, pal, with the week that was, something that's been happening, something you've been working on. What say you?
Well, certainly a lot to cover today, like we do on every show. There's so many issues that come up in the rubric of employment law. So if you are suffering with some problem that's been weighing on you, that's been bothering you, you may well get your answers right here on this show. We'll talk about a lot of things that a lot of people are dealing with their job, with their boss, with their workplace. So we'll probably cover what ails you or concerns you. But of course, you can always reach out to me privately. We'll have that information for you again a few times throughout the show so we can have a discussion. John, I've had a tremendously busy week, as I usually do. A lot of questions still. The pandemic still front of mind for so many people, despite everything about how it impacts jobs, job security, vaccinations. Can you be vaccinated or you cannot? We'll talk about all those things. But I wanted to start off with a situation that, of course, came across my desk. I spoke with a gentleman. He had been put on a temporary layoff for a number of months. He'd been off actually since last year on a temporary layoff. Now, he had watched the show and he understood that he has a right, if he wants to treat that layoff as a termination of his employment. He knew that he didn't have to accept it, and he could choose to say, enough is enough, I want my severance. And he frankly spent the last few months deciding, what does he want to do? Does he want to get a severance, or does he want to remain employed? Well, as he's thinking about that, he gets a call from his employer saying, we want you to come back to work. We want you to be back to work next week. So here's what crossed his mind. He wanted to understand, well, if I just go back to work, do I give up the ability to say constructive dismissal, that the layoff was a termination? I've been off for a number of months. If I go back to work, is it as if I've pretended that everything is fine, that I've given up my ability to say that's a termination? So he called me with this question, and the issue here is very simple. If you've been laid off temporarily, you get called back to work. If you just go back to work, have you accepted it, or can you still pursue your severance? So here's what I told him. If he simply goes back, doesn't say anything, pretends everything is normal, that's an acceptance of the layoff. He cannot go back and he cannot say that's a termination of my employment. On the other hand, if he says, I'll go back to work, but I'm still owed for the months that I've been off, in this case, he's been off about 10 or 11 months, then he still preserves the ability to get that compensation, to get that severance. So he wants to say that, just so you know, employer, by going back to work, I'm not giving up my entitlements to this date. So that's what he's going to do, and that's what you have to do as well. If you are going to go back to work after your temporary layoff has ended, you want to still preserve your ability to be compensated for the months that you have been off. And the best way to do that is to tell your employer, I am preserving my rights. I am not giving up those rights. Now, for many people, that layoff, that temporary layoff that you're on right now, I know there's thousands of people watching us right now across the country who have been on a temporary layoff for many months. You can treat that now, today, if you want, as a termination of your employment and get your severance. Your employer is not just going to tell you or that you can do that. Your employer is not going to just give you that severance. You need that help from us to get that. It's not a complicated process. So if you want to get your severance, or if you want to know how to respond to your employer when they're calling you back to work, you want to reach out to me as soon as possible.
So say someone's watching this and they're thinking, okay, tomorrow I'm going to call Lior because I'm still on a temporary layoff. I don't want to go back. I'm going to treat that as a dismissal, a layoff, permanently gone. I want my severance. But the day before today, your employer reaches out and say, oh, we need you back starting Monday. Since they've already laid that groundwork, is it too late for you to say, no, I'm on a layoff, I'm out, I'm done, I want my full severance?
Well, the thing is this, if you're still within your severance period, so let's say someone is owed 18 months severance,
Right.
and they're getting called back to work 12 months after they've been laid off. If they don't go back to work, they may be giving up some severance going forward the last 6 months. So in some situations, it may make sense to go back to work, even as a way to mitigate your damages, but you want to be on the record and in writing. By the way, whenever I say tell your employer, I always mean in writing, always.
Yeah.
Tell your employer in writing that you're not giving up your past rights. You're not agreeing that your employer can avoid paying you the severance that they owe you. For many people, John, even if you get called back tomorrow and you go back to work tomorrow, you could be owed months, 12 months, 13, 14 months pay right now. So you don't want to give up those rights.
Again, reaching out, don't pull the plug, don't do anything until you talk to Lior and his team at help@employmentlawyer.ca or simply employmentlawyer.ca, the firm website, which is where, I mentioned off the top, you can find links to our long-running radio show. Our broadcast has been going on for almost 9 years. We've been doing that. We get a ton of phone calls every week. Lior, as you know, we'll play back one now from the radio show and talk about it. First call for the day.
I work for a large corporation, and I've worked there for almost 14 years. Supervisory role. I had a meeting, and it was announced they were selling this location to a licensee, essentially, which means my nearest location to transfer to would be 54 kilometers away, an unpaid commute. I'm wondering what my rights are.
So obviously, whenever you're moving or being forced to move to a different location, that could be a massive change to the terms of your employment. Massive. And if you're now going to have to spend hours on end more than you would otherwise have to get to work, to get back home, that's a huge change. And whenever we're talking about a significant change to the terms of employment, that term of constructive dismissal comes to mind. A constructive dismissal happens when your employer makes a significant change. They reduce your compensation, they change your hours, they demote you, or they relocate you, like with this caller. So the fact that she was relocated gives her the right to treat this as a constructive dismissal. Now, it's not every relocation that results in a constructive dismissal. If they relocated you across the street, clearly that's not going to be a constructive dismissal. So to me, is if you're now spending an hour more a day to get to and from work, that's constructive dismissal territory. So it's not about how many kilometers away the employer has moved or has relocated you. It's about the impact that this has on you. Some employers may move 100 kilometers, but that could work out really well for the employee. It may actually be closer to their home. So that wouldn't be a constructive dismissal. But if you're looking at an hour away or so more a day because of this move, we're in constructive dismissal territory. Now, John, because this person potentially has been constructively dismissed, she's owed severance. So let's go to our friend, our pocketemploymentlawyer.ca, and let's find out how much severance she is actually owed. You could do the same thing. If you've been let go, constructively dismissed, whatever it is, you can go to pocketemploymentlawyer.ca to find out how much severance you're owed. So let's do that right now. We know that she has been a supervisor working for 14 years. You can see that on the screen. If, in fact, she chooses to treat this relocation as a constructive dismissal, she is owed, you can see it on the screen, right around 16 months' pay, potentially as much as 16 months' pay, depending on her salary. Well, that could easily be 6 figures right there. That's what she's owed. And the same with you. You can always check out your entitlements at pocketemploymentlawyer.ca.
So I guess it's how it affects the individual. I mean, if this person here drove to work every day, maybe they go, it's okay, it's a little more time to myself, I'll listen to some podcasts, I don't mind. But if someone has to travel the same distance, change 4 buses, well, that's a completely different story, isn't it?
Well, John, I had a client a number of years ago. She was an older lady. She did not have a car or even a driver's license, and she used to walk to work. She did the same walk to work for over 10 years every single day. Now, that employer had relocated about 12 or 14 kilometers away, not particularly far. But because of the fact that there was no way to walk there, she would have had to take 2 buses to get to this workplace. It would have gone from 10-minute walk to an hour and a half each way to get to work, even though the distance itself was not significant. That was a constructive dismissal. Clearly, for someone else, that 12 or 14 kilometers would not have moved the needle. It wouldn't have been a big deal. For her, that's a big deal. So the question is not how far your employer has moved. It's not what everyone else thinks. It's about how does this impact you, depending on where you live, depending on whether you drive, depending on whether you have access to a car. It may impact you very differently than someone else.
There's still another website you can use anytime called terminationquestions.com. It's really handy. Ask your questions there, and somebody from the firm, like Lior or otherwise, will get to it and give you an answer back. First one for today, Manuela. Lior writes, says, my boss is rejecting all my vacation time requests, saying that he can't accommodate them because of COVID-19. Isn't it up to the employee to choose when they take time off?
Well, I think that if we took a poll, most individuals would say, well, it's up to me, the employee, to decide when I take my vacation. Right. Sure, my employer can approve it or not, but I decide. And the reality is most employers allow that to happen. Most employers say, we'll let you choose, tell us when you want, and we'll try to approve it. But despite the fact that that's what employers do, a lot of them, an employer has the legal right to decide when an employee takes vacation. So an employer can decide for you without even asking you, you're taking your vacation this year from November 5 till November 10th. They can do that. And you may say, well, wait a second, I don't want to go in November. I wanted to go in August. Well, despite that, an employer can choose to have the vacation scheduled for you. Most employers don't do that because they would have very unhappy employees, but an employer can. So if you're now in a situation, whether it's because of COVID-19 or otherwise, where the employer is not being as flexible in terms of scheduling vacations, as long as you're still allowed to take your vacation time. Your employer can't say no vacation for you. But as long as your employer is still allowing you to take the vacation, the employer can be the one that chooses when vacation is going to be taken.
Is that only allowed if it's a clean slate as far as vacation bookings are concerned? For instance, you've taken July, you've bought airline tickets, you're going away for a week, and they say, no, you're going in February. They can't do that, can they?
No, certainly. If you've gotten your vacation approved already, you've relied on that, you've made arrangements. No, it would be inappropriate for the employer at that point to say, well, yeah, now we changed our mind. No. If the employer has approved it, if you've relied on it, you should be allowed to take that vacation. But if the employer has not yet approved it, they can say no or simply decide when you will be taking the vacation.
Short break, and then we're going to get into the truth about independent contractors. This is a massive topic. You'll want to stick around for this. In the meantime, 1-855-821-5900. help@employmentlawyer.ca. We'll continue. Employment Law Show. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Employment Law Show. Lior Samfiru and John Scholes here, reaching out 1-855-821-5900. Huge topic. We like to bring this up every few months, Lior, because it is such a massive topic and people are so much in the dark about this one. The truth about independent contractors. You'd agree, I guess. We get calls about this all the time on the radio show as well, right?
You think we get calls on the radio show? You should see how many calls I get in the office about this topic. It is one of the top 3 topics, if you will, in employment law. The idea that individuals are often misclassified. We'll talk about what that means, but most people that actually believe that they're independent contractors. I'm not an employee. I invoice the company. I'm a contractor. Those individuals, in the eyes of the law, are employees, and that comes with a lot of other entitlements and rights and obligations that arise in those situations. So we'll talk now about who really is a contractor, who has been misclassified, and what can happen if you, in fact, have been misclassified.
Let's do exactly that. Pull the curtain back. You may be surprised by some of these answers, but right off the top, difference between an employee and a contractor.
So an employee, of course, I'm not going to shock anyone by saying this, is someone that has a job and works for someone else. Someone that is not in business for themselves, someone that provides services to someone else. That boss, that company directs them, tells them what to do, and it's for the benefit of that company. So that's an employee, and we know it when we see it. We've all been employees at one time or another. Well, an independent contractor, in contrast, is someone that's operating a business. An independent contractor is someone that's in business for him or herself. Someone that doesn't have a job, someone that has a business, and they have customers, and they market their services, and they have a number of customers they provide services to. They have expenses that they have to manage. That is an independent contractor. The best example I always like to use is the plumber or the electrician that you call in. Let's say I have an electrical problem. I'm going to call an electrician. That electrician is going to come to my house. It's going to fix the electrical problems, and then it's going to go on to its next customer. That's an independent contractor. He doesn't work for me. He provided a service, and I'm going to pay him for that service. On the other hand, if that independent contractor came to my house every day, 9 to 5, and worked for me exclusively, well, that now starts looking like an employment relationship. So always ask yourself, are you really the electrician in the first example, where you have a bunch of customers? Or are you the electrician in the second example, where you go to one company, you do all your work there, and you go home, come back the next day to do the same thing? Which one are you?
So where else are employers and workers still getting this wrong?
Well, employees often get misclassified. It's very easy to say to someone, well, we're going to hire you as an independent contractor. Think how great that is. We don't have to put you on payroll. We don't have to worry about benefits. We don't have to pay EI or CPP. You just pay your own taxes. You figure it out. My gosh, what a wonderful arrangement. Well, except it doesn't work that way. If, in fact, you are an employee that's been called a contractor, well, then that's illegal. And if you think about it, if it was as simple as just telling someone, invoice us, anyone can do that. You know, you have kids working full-time or part-time at fast food restaurants. Why can't they be independent contractors? We'll just have them invoice us. We have people working in factories and assembly lines. Let's make them independent contractors. Well, it doesn't work that way. If you're not operating a business, you're not an independent contractor. You've been misclassified. You've been called something that you're not. And I want to remind everyone that what you call yourself or what the company that you work for calls you does not matter. It does not change who you are and what you are. The law can determine only if you're an employee or an independent contractor.
There's probably people watching this now that fit into that box, and they're probably thinking, you know, to use a tired term, at the end of the day, does it really matter? What difference does it make?
Well, it matters for many reasons. Number one is if you've been misclassified and you're being calling yourself a contractor when you're not, there could be potential issues with CRA. You've been trying to get deductions that you're not entitled to. Haven't been paying into EI and CPP. You could be fined. There could be penalties, back taxes. That's bad both for the individual and the company. But there's employment law issues as well. If you are truly an employee, but you've been misclassified, well, think about it. You're owed overtime pay. You're owed vacation pay, holiday pay. You're owed minimum wage. You're owed severance if you are let go because you're an employee. So you have an entire host of rights and entitlements that are owed to you if you are an employee, and you can't extinguish those entitlements. You can't eliminate them by misclassifying someone. So there's a lot of reasons why it should matter and why you care, and the company you work for should care, whether you're in fact an employee or a contractor. Chances are, I'll tell you how common this is, John, 9 out of 10 people that believe they're contractors are probably misclassified as employees. If you're now watching us and you're not sure, let me end the mystery right there. You're probably an employee, because individuals that are contractors, like that electrician that I gave you the example before, they know that they're contractors. They're not worried. They're not thinking about it. If you're now on the fence, you are an employee, trust me.
So if I'm sitting back and saying, yeah, Lior, but you know, I went in one day when I got this new job and I sat across from my now boss and we had a coffee and we both agreed, hey, you want to be a contractor? Yeah, that's great. I'm a contractor. We both agreed to it and we signed the contract. It wasn't forced upon me. So is that not good enough?
It's not, because anyone can sign a document. Anyone can sign a piece of paper. And remember what I said before, if that was that simple, let's get part-time workers at fast food restaurants and factory workers and everyone else to be independent contractors. They just have to sign a piece of paper. You know what? That means we don't have to worry about silly things like employment laws, because everyone will just sign that piece of paper. Well, it doesn't work that way, right? The law is smarter than that. So what you signed doesn't matter. How you pay your taxes doesn't matter. If you've registered to charge GST or HST, that does not matter, okay? If you have your own corporation, it doesn't matter. What matters is your relationship with the company that you work for. Do you take directions from them? Do you work for them exclusively? Do they pay for your expenses? Are you embedded in the business? If the answer is yes, even to some of these questions, not all of them, but even to some of those questions, you are an employee regardless of those other factors.
So if now this has been cleared up and somebody watching or several people watching are going, oh, you know what? I think I might actually be an employee. I've been calling myself a contractor. I thought I was all these years. What do I do?
Well, first thing you want to do is get some tax advice, because you may want to be very conservative with how you file your taxes and what expenses you're seeking to deduct, because at some point this can turn around or come up and blow up in your face if in fact CRA determines you've been misclassified. So you want to get some tax advice to minimize that liability. The other thing is this: you will have to decide whether or not you want to say enough is enough. I want to get my outstanding overtime and vacation pay and holiday pay. If you want to, yeah, we can make that happen. We can do it now. If you don't want to rock the boat, I guess you stay as you are. But what you have to keep in mind at that point is this: if the company you work for lets you go because you are really an employee, you have to get your severance, and that severance could be as much as 2 years' pay, 24 months. So at a minimum, remember that. If you're a contractor but are really an employee, you've been misclassified, you don't want to rock the boat at this point, fine, I can't make you, but I want to make sure you get your severance if you are ever let go. 24 months could be at stake. If you find yourself in that situation, give me a call.
Before we take a break, I want to get to one more phone call from our radio show. Lior, we'll do that right now.
But my question's more on behalf of my employer. I know that there's an employee working at the company I work for, and he's been there for about 5 years, and I know that he's been disciplined, and the talk amongst, I guess, the other employees is that he has anger issues and he's taken them out on employees. He has been disciplined. He has been suspended. On behalf of the employer, can they let this employee go?
Sure. If the employer can show, number one, that the employee did something wrong, or obviously a number of things wrong, number one, if they can show that. And number two, if they can show that the employee was disciplined, he was given opportunities to improve, he was told that he may lose his job if he doesn't shape up. Yeah. And number three, if they can show that despite this, the employee continues with his bad behavior, yeah, that employer may be able to terminate that employee for cause, meaning no severance would have to be paid. But they have to make sure that the employee has been disciplined and what the employee did is serious. In many cases, John, you know this, we've talked about this on the show before, employers try to terminate employment for cause just because the employee did something wrong. But the employer doesn't build up its case, doesn't provide prior discipline, doesn't give an opportunity to improve, that would make it a wrongful dismissal. But if you've ticked all the boxes and you've built up the case as the employer, yeah, you can terminate for cause for sure.
We'll take a short break. 1-855-821-5900 to reach out. Lots more Employment Law Show is on the way.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Thanks for hanging around Employment Law Show. Anytime you want to catch our radio show, you can do so. EmploymentLawyer.ca is where you go for lots more information and a station near you that carries that show. Lior, let's get to one more phone call for this program from the radio show right now.
A friend who he was employed, I think, 29 years. Now, with this COVID thing, he finally received a notice of termination, and they offered him $15,000 as his severance. He's 62. I'm just wondering his options on this one.
Man, oh man, I love those long service. And that's not even the same ballpark. That's not even the same sport. 15,000 after that long.
It's the same activity, not even close. So let's be very clear. The factors that go into assessing how much someone is owed are your age, your position, and the length of your employment. So this person scores very highly in the sense that he's been there for 29 years. He's 62 years old. Yeah. So this person, forget about 15,000, he's owed 24 months pay. So unless he's earning $7,000 a year, this employer has no idea what it's doing, and that's a wrongful dismissal. Now, I know that I spoiled the punchline. I told you that he's owed 24 months pay, but I still want you, everyone at home, to go to pocketemploymentlawyer.ca. We'll do that right now to see how you or him or anyone could find out now how much you're owed if you lost your job. So let's turn over to pocketemploymentlawyer.ca and use our severance calculator feature there. You can see on your screen, he's been there for 29 years in a sales role, 62 years old. He was offered $15,000. You see at the bottom, as I've said already, he's owed 24 months pay. That delta, that difference between $15,000 and 24 months pay is going to be huge. It's going to be massive. That's a wrongful dismissal. That's the bad news. The good news is it's not difficult to resolve these things at all, and I'll make sure that happens.
TerminationQuestions.com. Let's get one more of these in, Lior, with our remaining time on the show today. Jenna says, I've been ordered by my doctor to go on long-term disability because of my mental and physical health has been severely affected by COVID-19 pandemic. My boss said I'm overreacting about everything and that he can guarantee that I will not have a job to come back to when I am able to return. Not sure what to do.
Well, maybe the boss even thinks COVID is not real. I don't know. But my gosh, what a silly thing for an employer to say. And it's silly for many reasons. But for our purposes, it's silly because her doctor says she cannot work. It doesn't matter what the boss thinks. It doesn't matter what I think. If a doctor says you cannot work for whatever reason, it could be a mental health issue, it could be a physical ailment, whatever it is, you can be off work and your employer cannot do anything about it. And if her employer is threatening that she would lose her job if she takes off for medical reasons pursuant to her doctor's orders, not only would that be a wrongful dismissal, that would be a human rights violation as well. I know many of us have struggled with mental health issues over the past year plus because of the pandemic and other reasons associated with it. You are allowed to be off work if you have those issues. You need that doctor's note for support. Once you have it, your employer cannot do anything to you. You're protected. If your employer tries to dispute it, tries to say you have to see someone else, they don't believe you, they don't want to accommodate you, they threaten you, any of those things or anything else, call me. It's illegal. Mental health issues are real. The fact that you can't see them on an x-ray does not change that. And your boss, your employer cannot question you if you have a doctor's note.
This is going to continue, I think, as COVID-19 progresses, even when it ends for some time, right?
It's not going away. Things, unfortunately, are going to continue, and we will have people that are impacted, their health is impacted. Employers have to adapt and understand and be supportive in those situations.
Lots of stuff to cover there. Hope you got most of it. If not, you can reach out anytime to Lior and his team. The phone number first, 1-855-821-5900, employmentlawyer.ca, the website, and help@employmentlawyer.ca to reach out through email. Catch you next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.